determining lost profits, do you need to consider non-infringing alternatives that the alleged infringer could have sold in place of the accused products?
Yes, the short answer is yes, they need to be considered. It's a very fact-specific inquiry, but the Federal Circuit, I believe in grain processing, really described how reconstructing the but-for world requires that you consider alternative actions the infringer could have taken as opposed to leaving the market altogether. But those alternative actions need to be very, very they can't be fantasy. They need to be well-grounded alternative products that are really available and acceptable to those customers. So the available and acceptable question is really the key part, and there's some pretty tight law, as I understand it, on what constitutes an available and acceptable non-infringing alternative. It needs to be considered, but it needs to be considered very carefully.